The next case and final case that we're going to hear oral arguments on this morning is case number 21CA011811, Roth versus Tokar Tower Office Condominium Unit Owners Association. And panelists for this case will also be Judge Carter, Judge Sutton, and myself. The appellant may reserve up to 5 minutes for rebuttal. Each of you, of course, will have 15 minutes to present your argument. I'll keep track of that time and let you know as you get close if you let me know how much time you would like to reserve, if any, for rebuttal. Also, we don't use the names of children, which I don't think is a problem in this particular case. Judge Carr, Judge Sutton, and myself have read the briefs. We are prepared to proceed if you are. So, Attorney Roth, how much time, if any, would you like to reserve?
5 minutes, Your Honor.
5 minutes? All right. Now, I may interrupt you and let you know as you get close to that time, but feel free to begin.
Good morning, Your Honors.
Good morning.
This is an appeal of the trial court's granting of summary judgment to Appellee Tokar Office Condominium Unit Owners Association, Inc. on the appellant's claim for negligence, violation of the declaration bylaws, violation of RC 5311.14, breach of fiduciary duty, intentional tort, slander of title, and punitive damages. My argument basically is there are genuine issues of material fact on all these claims. And all these claims should have went to jury trial instead of decided on the summary judgment. First of all, the negligence claim, there's a material issue of fact on whether this was actually an act of God or not. They claim it is, I claim it's not. Ohio has bad winters in the past. Since this building was built, there's been bad winters in the same proximity. And
was this unique in that I thought I read it, this was like in the top 10 coldest winters?
It was the top 10, but no, I guess what I'm trying to say is like since the 50s, since the building was built, there was cold winters like that. I mean, I think the argument was made that recently there hasn't been this cold winters, which I agree with. And even if it was an act of God, the Tokar's actions was compensatory with that's acting in you know what it is. It's getting the act of God wasn't alone. It was concurred with a negligent act by Tokar. The negligent act is that that they should have reasonably anticipated, guarded against, and foreseen an act of God if there was to avoid injuries. Some of the things I think they could have done is guard against the pipes being frozen, maybe insulate the pipes, and also they had a duty to make sure all the electricity was on. According to the bylaws, they're responsible for the electricity until the meter is turned over to the unit owner. And in this case, there wasn't even a meter on the unit. So they would have had to initiate the meter first and then transfer it over to me for me to be responsible for the electricity. I couldn't turn the electricity on because I had no ability to do so. There was no meter on for the electricity. And I think the reason for that is it's an old building. It was owned by it was owned entirely by the bank at one point, and there wasn't electricity there for a while until I bought it. Okay, so that's a negligence. Number two, the bylaws. according to the bylaws, as I just stated, they're responsible for the common areas. The initiation of the problem was in the elevator shaft. The pipes in the elevator shaft burst. The elevator shaft and the pipes are common areas, which is the responsibility of the association.
Attorney Roth,
Yes.
can you just clarify a couple of things for
Sure.
me? So you're referencing the bylaws, but I'm trying to understand how was the fiduciary relationship between yourself and the condominium association? How did that arise? Was it in the where in the condo association contract does that duty arise?
I think I mentioned that in my brief. It was based on the declaration requiring Tokar to provide for maintenance and improvement of the common areas, as well as RC 5311.14A. And that's briefed in my initial brief, number 3.
Thank you.
And I believe there's some case law for that, but I didn't include it for some reason.
Thank you.
Okay, you're welcome. Violation of RC 5311.14, that's pretty much self-explanatory. Unless provided otherwise in the declaration, damages or destruction to the common area shall promptly be repaired or restored by the management.
Attorney Tokar, do you dispute that I'm sorry, Attorney Roth, do you dispute that they failed to promptly repair? Did you present evidence that they failed to promptly? So I'll find that in the record?
Yes, you will.
Okay. What kind of evidence was that?
Testimony, the fact that it started in the elevator shaft, that's a common area. I believe the bylaws do define what common areas are.
But were they on notice that the repairs needed to be made? Because my understanding was immediately after the pipes burst, Tokar hired somebody to come in to start repairing and restoring the building. Was there any notice before the event happened that the pipes were in need of repair?
I don't know, like I say, we didn't go to the jury, so I guess I wouldn't ascertain what people went to the jury. But they just thought that there was no material issues of fact, and it clearly wasn't. There was a difference of fact.
Attorney Roth, are you arguing strict liability, that the condo association is strictly liable?
No, I'm just arguing for 5311.14. I guess you can ascertain that arguing 5311.14 would imply strict liability, but I don't know if I would read it that way or not.
Thank you.
You're welcome. And we went over the fiduciary duties, so I'm not going to go over that again. One of the final ones is that I made a claim earlier that they went into the property and not only changed the locks, but started taking my books out. How I found out was I was on the elevator going up to my suite, and I noticed there was a gentleman that was loading books up, and they looked at my books, and I said, where did you get those books from? And he told me. I ended up finding out that they were from the Port Authority, and they were hauling all my stuff out. And there was a big misunderstanding that they thought my unit was connected with another unit on the same floor. And once I saw the Port Authority, I was able to clear it up, but I admitted the claim that, because at the time I had no idea the Port Authority was doing it. All I knew was my locks were changed, I couldn't get in there for months, it was a big inconvenience.
Now, the Port Authority is not a party, are they?
No. Yeah, I just said that to sue the Port Authority. I mean, I really didn't lose any books. I managed to get them before they started trucking it off in their truck. It's mainly the inconvenience of not being able to get into that suite for months.
I could not hear that. The inconvenience of what?
Not being able to get into the suite for months because the locks were changed and I couldn't get in there. So I amended a complaint and from telling them that the Tokar response was responsible because only they had the key, so I just assumed that I wouldn't have changed my own locks and I'd be able to get in there, so it had to have been Tokar.
Attorney Roth, you are at the 5-minute mark right now. You want to continue?
No,
Save that for rebuttal?
I'm good, thank you.
Okay. We'll let you 5 minutes for rebuttal.
Thank you.
All right. Is it Attorney Duffy?
Yes.
All right. You'll have 15 minutes, sir.
Thanks, Judge Theodosio. My name is Matt Duffy. I represent the appellees in this case, Tokar Tower Office Condominium Unit Owners Association, Inc. As the judges have highlighted, the crux of this appeal involves the act of God defense and, quite frankly, the appellant's inability to overcome that defense. The damages of which Mr. Roth complains are damages to the contents of his unit, namely primarily law books. It was caused by the pipes bursting, and actually there was testimony that it may have been 2 pipes bursting from the cold weather in 2014. The water cascaded down, causing damage to other units in addition to Mr. Roth's unit. The trial court was correct in granting summary judgment in favor of Tokar Tower. Mr. Roth's testimony, he said under oath, the only thing that I know is that your client, Tokar Tower, takes care of the pipes got frozen, and there was a flood. That's essentially his case.
So, counsel, you're relying on the fact that he didn't have an expert or anything that said that the pipes could have been insulated or...
It's certainly one of the factors. I think what you see today, Judge Carr, is that Mr. Roth is, in a sense, testifying on his own behalf. There are several theories that have even been briefed that there's no evidence to support that. If you look at the testimony of Jay Tokar, the president of the Condo Association, I mean, he testified that he was not on notice of any problems with the pipes, and there were, Simplified Facilities was charged with the duty of inspecting the pipes twice a month. They provided him with no notice of any problems. They provided him with no invoices for repairs. And this
Counsel, let me just ask you a question. So there were depositions that were had. Were there affidavits?
There were no affidavits other than Mr. Roth's self-serving affidavit, which quite frankly just restated the allegations in the complaint. So no, there were not affidavits.
Well, that's an affidavit, but I understand your point.
Yeah.
Okay, so I guess what I'm wondering is, and obviously we'll have to review all this, but what the evidence was in regard to that the pipes weren't insulated, or there was no heat or whatever. And this was one of the coldest winters in history.
And one of the coldest winters in history in Northeast Ohio.
Yeah.
So as Your Honor knows, in case law in various cases, I mean, we admit that Northeast Ohio, we have cold winters, and that's something that is normal. Now, but again, there is no evidence in the record, none, that there is any problem with the pipes. Mr. Roth speculate that there was a failure to insulate the pipes. There's no evidence of that.
Well,
None.
Council, I guess what I'm getting at though is, as a homeowner, whenever there's a really, really cold winter, you know, usually you get notice on the news, everybody check their pipes, everybody be careful, you know, do what action needs to be taken in order to make sure your pipes don't burst. So I guess I'm wondering, what was the evidence or testimony in regards to that?
Well, that would have been J. Tokar, who was deposed by Mr. Roth's prior attorney. J. Tokar, again, he relied on simplified facilities. He stated, look, he's an accountant. He said, this is not my expertise. I rely on simplified facilities. They're the contractor. And his testimony was, to the best of his recollection, they come in about twice a month. And if there's any problems or anything that he needs to be aware of, they tell him about it. Otherwise, they just do whatever their job is. And if there's an invoice, there's an invoice. But he was not alerted to anything that was anything out of the ordinary.
Well, I guess that's the other question I have. Do you have to, in order for him to prevail with this claim, you don't have to necessarily show that there's anything wrong with the pipes, right?
It doesn't have to be something wrong with the pipes, there has to be some notice of something. You know, otherwise you just...
What about the notice of it being the fourth coldest winter in the Northeast Ohio area?
I think that's inadequate, Your Honor. That would be, I would say that would be more of almost a strict liability. Therefore, every time, I mean, how we get to know, we can know it's going to be cold, but the fourth coldest winter, what if 3 weeks later it's the fifth coldest winter? There's a certain amount of understanding with the act of God that there really has to be some other affirmative evidence showing that that an act of negligence contributed to the act of God.
Let me ask you this. Can you give me a better understanding of how these pipes were situated? I don't think there's any dispute this in the common area, right?
There's no dispute that the pipe is in the common area.
Were they completely, I mean, there are no pipes exposed to the elements, was there?
Not that we know.
Not that, what does that mean?
Meaning that issue wasn't really explored by the appellee in this case.
Okay, can you give me a description of where these pipes were located?
I cannot give you a full description of where the pipes were located.
Okay, because there's nothing in the record about that.
There's nothing in the record about it.
Thank you.
But we did provide affirmative evidence, primarily through J. Tokar, that, you know, as Judge Carr pointed out, there was no expert report or other evidence of causation. We were not aware of any problem with the pipes. And again, as I stated, simplified facilities, they were on the premises twice a month and reported no problems to J. Tokar. I should note that in Mr. Roth's brief, there's no mention of that testimony at all. He doesn't challenge the testimony of J. Tokar. Nowhere is there any challenge to the evidence that we put forth on behalf of Mr. Tokar. Also, in Mr. Roth's brief, there's no mention of simplified facilities. So the evidence that we've provided in seeking summary judgment that is undisputed is the evidence that Tokar was in contact with these contractors who were charged with certain duties and who did not notify him of any issues that he would be aware of, something that would show active negligence in addition to the act of God. Now, I do want to point out, there's been a little bit of discussion here today about the bylaws. I think it's important, it was a little unclear in some of the questioning that Mr. Roth complains of the damage, he references common areas. There is no dispute that the common areas have been repaired. The common areas have been repaired. That is in the testimony of J. Tokar. Mr. Tokar promptly notified the insurance company when he was aware of the incident. Platinum Restoration provided remediation efforts, and Simplified rebuilt the damaged structure. They rebuilt it. Those common areas, it's been fixed. The area has been fixed. What was not fixed was the contents to Mr. Roth's unit. Those are his personal contents that he chose not to insure. If you look at the bylaws, it mentions that the association, their insurance shall not prejudice the right of any owner to obtain their own individual property insurance. So it anticipates that an owner may want to protect the contents to their building, to their unit if something bad happens. And that was...
Let me interrupt you on that, because when I was reading that in the brief, I wasn't quite understanding that.
Okay.
I understand that we can all have additional insurance, but that doesn't stop there being a cause of action necessarily for negligence.
Not for negligence, but as far as in theory, not for negligence, Judge Carr. What I would say is that the damage, that if you look in the bylaws, it references damage to the common areas. And the common areas, again, were taken care of, were fixed. It does not mention the contents of an individual unit, so the reference to the insurance is certainly an indication that that is not something that's being covered.
I was thinking, like, for instance, because we've gotten so many of these cases over the years where a common area, the allegation is not maintained adequately and somebody slips and falls. Okay. Well, under your theory, couldn't the condominium association come in and say, well, we repaired the place where they slipped and fell, they should have had insurance?
Well, I think that'd be a little bit different, because I think if you're talking certainly of an injury case, an injury could happen anywhere, and if you're charged with the duty to maintain the area, you're going to be responsible if you're negligent for causing the injury to that individual person. Whereas this is in a unit which they own. Mr. Roth owns his unit, and so when you're dealing with, this could be a little bit more of an insurance question, but when you're dealing with contents of a unit as opposed to common areas, there's certainly a different risk involved, and insurance companies are going to look at that much differently than a common area. And
Counsel, let me just explore that a little bit more if you don't care. So if, as just hypothetically, there was evidence, genuine issue of material fact of negligence here, would you still be arguing, or let's just say that it's completely proven that negligence exists in some way in regard to the burst pipes, would you still say that your client is not responsible based on the fact that you didn't have a responsibility in regard to his unit that was damaged as a result of that negligence?
no, that would be a little different. And that would be different. I think that's akin to your analogy dealing with personal injury. And that is, that would be a tort negligent action, and it would be independent of the agreement. I'm mentioning the agreement because of the additional claim by Mr. Roth. Mr. Roth is saying that the condo agreement was violated. So that's why that is a separate claim. That is not a tort claim. If you're bringing up a tort claim, which absolutely we would be responsible. If we were negligent and the negligence approximately caused damage to Mr. Roth's property, even if it were insured, yes, we'd be responsible. I bring up the insurance question more to look at the violation of the bylaws. And under the bylaws, it mentions common areas. It does not, the only mention to contents of a building is in the passing reference to insurance. So in that sense, I'm saying there's an implication there that under the bylaws, they're not responsible for the contents. But again, a separate tort action, as Your Honor points out, in your hypothetical, yes, we would be responsible because that would be a separate tort action.
Thank you.
I do want to bring up in my remaining time here that there are a few matters.
2 minutes.
2 minutes, thank you, Ron. Appreciate it, Judge Stevens. There's been some discussion with Mr. Roth about the alleged intentional unlawful unlocking of the doors. It should be pointed out, my client did not do that. There's testimony that my client did not do that. Mr. Roth, under oath, has admitted that my client did not do that. And I just think that's something that the judges should discuss in looking at something else.
And just in regard to that, so he admits that the Port Authority was responsible.
Yes.
It was an error, but he's saying that your client still gave him the key, still gave the entity the key.
I think that was under authority of the Port Authority, though. That was in compliance with the order of the Port. The Port Authority came in to evict certain people on that second floor.
So was there any evidence of any type of order that provided that his unit was to be evicted by the Port Authority?
I think there was just a testimony, but no, Your Honor, I don't think there was. I didn't think there was. But what I do want to point out is the testimony in Mr. Roth's deposition, Mr. Roth admits that he would be dismissing that claim. I think that's what's important about his testimony. And we believe that the trial court was correct in granting summary judgment. We would ask the court to affirm the lower court's ruling. Thank you very much.
Thank you. Attorney Roth, you have 5 minutes. Rebuttal.
Thank you, Your Honor. A few things I need to clarify. First of all, Mr. Duffy says that only the contents of my unit was destroyed. My entire unit was destroyed. Not just the contents, but the physical part of the unit. And I did supply a bill. It should be part of the record. So that's not true. There's more done than just the contents. Yes, they can say that they did something after the fact, but they didn't do anything before the fact. I mean, they didn't do anything to prevent the injury. And I notice Mr. Duffy makes no mention of the fact that that his client didn't provide electricity for the unit that they were clearly responsible for, because there was no meter on it. According to the bylaws, it's not the unit owner's responsibility until the meter is transferred to the unit owner. It was clearly not transferred to me because there was no meter. And in addition to that, they needed to initiate putting the meter on there. I couldn't do it myself. In fact, after the fact, I tried to get the electricity turned on after the fact. I couldn't do it. I had to tell Tokar, you have to initiate this, and they did it, and it was turned on after they initiated. So there's nothing I could do. And I did not agree to drop that last comment about getting into my unit and changing the locks. I did agree that after I found out that the Port Authority is the one that changed the locks, I did agree that they were the ones responsible for changing the locks, but they still had the responsibility of getting them in there. Had Tokar not given them the keys or unlocked the door, they wouldn't have been able to get in there. And it was all a big mistake, and it could have been avoided if they just would have not given them the keys, or at least investigated to see if this was proper or not before giving them the keys. I still believe they're negligent for that. And also, as far as the act of God is concerned, I do believe they concurred with the act of God. It wasn't just the act of God that was responsible for this. It was Tokar's concurrence with the act of God. So they're comparably liable for the percentage of the damages, which the jury would have decided what percentage would be liable, but we never got a chance to go to the jury. And Obviously, this is a different standard. I mean, it's a genuine issue of material fact should have went to the jury, and then we would have been arguing different things had the jury decided. That's all I have. Thank you.
All right, thank you both for your arguments. Court will take the matter under advisement, issue a decision in due course. A copy of that decision will be mailed to you by the clerk's office the day it is released, and the opinions are also posted on the Supreme Court of Ohio's website. Now, the court will be adjourned for